All right, so we're about ready to begin with our second panel of the day. Thank you all for hanging out, and I know a number of folks have elected to join us via the live stream, which probably a good option as well. I'll say the first panel of the morning, and I suspect the second one is just incredibly helpful. I think both in terms of the public dialogue, and that has tremendous value, but also a lot of us moderating these panels are the ones with the sort of arduous task of working through the comments and updating the guidelines. And I can personally say, and I know I spoke to some of the other folks, it's just tremendously helpful to hear this dialogue and the engagement as we work through our process internally. So I want to thank everyone from the first panel and advance from the second. We have a distinguished group of public interest and academic perspectives on this panel. I'll introduce a few folks, and then my co-moderator, Andrew Sweeting, will introduce a few folks. We're joined by Avery Gardner, who's the Senior Fellow for Competition, Data, and Power at the Center for Democracy and Technology, which is a nonpartisan think tank and advocacy organization. She has experience as an in-house competition lawyer at Verizon and here with us at the Antitrust Division, both as a trial attorney and as counsel to the Assistant Attorney General for Antitrust, in addition to experience in private practice. So thank you for joining us, Avery. I'll also introduce Charlotte Slayman to my left. Charlotte's the Competition Policy Director at Public Knowledge. Prior to joining Public Knowledge, she worked at the Federal Trade Commission in the Anti-Competitive Practices Division, investigating and litigating antitrust conduct violations, including the 2017 case against 1-800-CONTACTS for manipulating Google search ad auction. She also has Hill experience and, like me, went to the New York University School of Law. We're also joined by Christopher Yu, Professor Christopher Yu from the University of Pennsylvania. I think well known to many of you. He's the John H. Chestnut Professor of Law, Communication, and Computer Information Science. He's been a somewhat frequent speaker at some of our events and always has a lot to offer. Andrew, can you introduce the rest of the panel?
Sure. So Aviv Nevo is the Penn Integrate Knowledge Professor at the University of Pennsylvania, where he holds appointments in both the Economics Department and at Wharton. He's also served as the Economics Deputy Assistant Attorney General here at the DOJ. And for this panel, he has particular experience thinking about bargaining models in antitrust markets, including in the context of healthcare. Steve Salop is well known to all of us. He's a professor at Georgetown University Law School, where he teaches both not only antitrust law, but also economic reasoning and the law. He has a lot of work looking at exclusionary conduct in vertical contexts. And I think all of us have benefited from reading the several different comments he submitted as part of designing the new vertical merger guidelines. He's also served as Associate Director of Special Projects at the Bureau of Economics at the FTC.
And with that, we're going to give each of our panelists a few minutes to do sort of an opening statement and go over some of their thoughts before we get into more detailed questions. We'll start with you, Professor Yu.
Well, thank you very much for inviting me here. Oddly enough, Aviv and I should probably thank our Provost, Wendell Pritchett, for allowing us to come, as is appropriate for the coronavirus. 2 days ago, we were notified by the university to suspend all university-related travel for the next month without special permission of the provost. So by his agreement, we're here through some efforts and gyrations, so we're delighted both to be here. Delighted to have the chance in this particular venue. I'd like to make 2 brief points in the short time that I have. One about the ordering of the discussion of market definition and concentration and the treatment of EDM, just looking at the guidelines themselves. Starting first with the ordering of the provisions, I found the distinction between the draft 2020 vertical merger guidelines and its organization and as compared with the 2010 horizontal merger guidelines to be quite striking. Historically, merger guidelines had always started off with discussions of market definition and market concentration, but the 2010 horizontal merger guidelines were quite different. Instead of starting there and moving to anti-competitive effects, the 2010 merger guidelines changed and actually made anti-competitive effects the first substantive provision of the guidelines before proceeding to market definition. And then added a caveat to the statement of market definition that for certain kinds of analysis, it may not even be necessary to define markets at all. And this is a major step because, as we all know, a huge fight in merger analysis is this enormous, extremely detailed, and I would say sometimes a largely unsatisfactory fight over market definition. And it really reflects an evolution in economic thinking, which was from the 1960s, we were dominated by what we called the structure, conduct, performance paradigm, where we thought certain structures led to certain conduct, led to certain performance, and actually we didn't even have to pay attention to the conduct, but the structure was enough. But it was recognized at the time the only reason you would go through such an inferential process is because we didn't have direct evidence of performance. My interpretation of the 2010 guideline change, and it's borne out by the discussion around it, is that the provisions were reordered in a recognition that our empirical tools are much better now. And that we've actually seen enforcement authorities block mergers on the basis of pure empirical evidence of price effects without any elaborate market definition. You know the cases better than I, and as well as I won't go through them, but that was an interesting revolution that I think really was reflected in that change in the guidelines. And it's a focus on effects in practice. I was very much struck by the fact that the draft vertical merger guidelines didn't carry that through. And that in fact, you saw a return to this notion of market definition and market concentration up front, instead of actually looking at the theories, at the effects. And in this day and age, I think that is a mistake. I think that the modern development of economic thinking and the increasing emphasis on empirical work would making the vertical merger guidelines follow the same form as the horizontal merger guidelines really advisable. And I think that something has been said in some of the comments that we also have to remember that we have to think about it not just as the ability and the incentive, but the actual impact. We've had some discussion in the previous panel about different market structures, particularly with respect to raising rivals' cost. It's interesting, you can't actually talk about the structure in the abstract. Many of the theories, particularly of raising rivals' costs, require a dominant firm model, which requires, for example, significantly higher market shares, typically than the 20% in the guidelines, the draft guidelines. Other theories could require less. It all depends on how the actual motivation of the harm is played out. The other reality is the empirical base for the price of the anti-competitive effects is much larger for horizontal cases. In fact, the relationship between horizontal concentration and price effects has been called the most studied empirical question in economics. I think that there's a wealth of vertical theory, but even though there is an extant empirical literature on vertical, I think the more objective surveys have said it's fairly thin. It's not as robust as we would like. And particularly because there's a wealth of vertical theories, it's very hard to line up actual empirical validation in the empirical literature with particular cases, particular examples of the vertical integration theories. Briefly on EDM, and the other point I was like to make is about EDM. My read of the draft guidelines is it places the discussion of EDM in between, which is in section 6, in between the discussion of unilateral effects in section 5 and collective effects in section 7 and coordinated effects. And so it seems to suggest that it regards EDM as part of the effects analysis. And there's a separate section for efficiencies that happens after that. And if I were to read these guidelines, my assumption would be is this would be part of the effects analysis. We've heard a robust discussion before about whether that's appropriate. My own personal view is that it is appropriate, is that it would regard as taking it as part of the basic price effects case before you get to the efficiencies. I'm sure that's going to be a matter of some discussion, but at a minimum, this requires some clarification, some explicit recognition of what the role of that's going to be, and I'm sure we'll have a much more fulsome discussion about how that will all play out. But consistent with what Commissioner Wilson said in the beginning, there is an argument, certainly with respect to certain cases, that EDM might be a core price effect that should be taken into account. I think the previous panel pointed out it doesn't arise in every model. It doesn't arise in diagonal mergers, these different forms, all which to me underscores the reasons to really tie actual analysis to specific cases instead of generalities.
Thank you. We'll turn next to Professor Nevo.
Okay. First, I'd like to thank both the DOJ and the FTC for inviting me to speak here today, and I guess more generally for organizing these workshops, and I guess to our provost for letting us both come here. Well, at least for now. Hopefully, I'll come back healthy. See how I might change that second part. Anyway, let me just get straight to the point. So I think pretty much everyone's in agreement that the 84 guidelines or whatever fractions of them kind of talked about vertical are out of date, and it's good to officially withdraw them. I don't think, at least I haven't heard much disagreement on that. That said, I'm a little bit torn about the current guidelines. In particular, I worry that unless the draft guidelines are significantly revised, they might actually create some confusion. And therefore, I hope that a lot of the comments that are the written comments and the ones that are in today's workshop and the workshop next week will lead to some significant revisions. So how should the draft be revised? In short, well, it needs more trees and it needs more forest. But everything else is fine. So let me try to kind of get into that, and let me mostly focus on the forest aspect. We're going to talk much more about trees later on. And let me kind of emphasize, 2 or 3 points. So the first point is, I believe that the scope of the guidelines needs to be clarified. There was a lot of discussion of that in the first panel. So let me kind of mention a few examples. There's a brief definition and a footnote of what a vertical merger is. And I think, we need to significantly talk about what exactly would that include. We already mentioned diagonal mergers. We'll talk probably about them later. How general is the supply chain? Are we talking about vertical relations or vertical supply chains that currently exist, or ones that could exist in the future? Okay, and I'm not saying that the guidelines should be definitive about them, but they should at least give some hint as to kind of what is the scope of what's being discussed. Another big issue, and I'll refer to kind of the submissions that we have, is are mergers between complements included? Or are we really talking about this kind of very traditional, upstream, downstream supply relationship, or are we talking about something that's more general? And then finally, again, another point that I think was discussed briefly in the first panel is, what if we have a merger that touches has both horizontal and vertical elements, right? And you can think of a lot of sort of different examples. Where do one set of guidelines end and another start, right? So both kind of maybe having kind of a clear or clearer line of when we should be looking one way or the other, but also saying, how should mergers be evaluated? Which is the one? Maybe the rule is they should be evaluated under both, and whichever is more problematic is the one the agencies would focus on. Maybe there's some other rule, but either way, I think leaving it kind of unspoken is problematic. And I especially worry about this last point because I could imagine that, especially lawyers would like to start labeling things of saying this is a vertical deal, okay, or this is a horizontal deal. Not saying, well, it has a little bit of both, right? And the problem is if you start labeling things or pigeonholing them, if you want, is that then the whole argument is like, should we use these guidelines? Should we use that guidelines? Instead of focusing on what is the economics of it, okay? So, and I think that's why it's important to try to clarify as much as possible, try to unify the framework as much as possible, because at the end of the day, and again, I'm sure it's something we'll talk about later, many of the same effects and many of the same concerns arise in both. Okay, so that's the first point about the scope. Second point, the guidelines, and this is really the kind of the big forest picture, the guidelines are missing a framework. Okay, and this goes, I think this kind of dovetails nicely with some of Christopher's comments from before. So what do I mean by that? Is one of the submissions, and sorry, I should have looked up which ones and exactly what they were referring to, but one of the submissions said something like, antitrust rules must be clear enough for lawyers to explain them to clients. Okay, that was kind of the reference that were made. I believe it was a comment made by Justice Breyer, but I should have actually checked that to make sure that's correct. Well, for that to happen, for lawyers to explain them to clients, first economists have to explain them to lawyers. Okay, that's a fact, want it or not, right? And whether it's Bob or Steve, that has to happen. And it's a bit harder in vertical mergers. Okay, and we can pretend it's not. We can pretend it's easy. We have all the answers, but we don't. And we don't have the answers both in terms of theory, because we have a richness of theory that don't give maybe as unified of a prediction as we might in horizontal. And we have some evidence, but the evidence that we have is not as rich as we would in the case of horizontal mergers. So it's going to be harder because the questions are harder, but that doesn't mean we shouldn't try. Okay? So in our submission, we've actually tried to put forward kind of a framework, and I'm not going to go through the full details, but in my view, any framework and any discussion we had really has to start with some discussion of what are the issues that we're going to face. Okay? And I think, what we did in our submission was actually put that framework in the form of, 4 questions. Okay? And in some sense, referring to comments that were made in the earlier panel, this is the why. Okay? Why is it, or what is it, what is it we're worried about? We can later talk about the how we're going to worry about them. So to go through these, quickly, the first question is really about the question of ability. So does the merging party in the related market, as it referred to in the guidelines, have the ability to influence competition in the relevant market? And obviously, the more competitive the related market is, and we can talk about how we want to measure that, the more competitive it is, the less likely it is to have this ability. So I think it's important to set that as the guiding principle of this is what we want to do. And then we can talk later about whether market shares achieve that or not, or we should do other things. But we need to achieve what is the principle we're trying to solve. Second question we have to answer. Does the merging party in the related market have the incentive to use that additional ability that it would get because of the merger? Again, we can talk about how we're going to measure that, but just establishing that as a principle of this is a discussion we have to have. We first have to talk about ability, then we have to move on to incentive. Third point is what's the nature of the pre-merger contractual limitation? Okay, a lot of discussion. That's a lot of where the last panel ended. That's an important key. It's not going to be an easy discussion, but it has to be part of the discussion, and we have to lay it out as a guiding principle of these are the things we need to talk about. Okay, whether it's engagement with the agencies, whether it's litigation, whether it's building a case, that's kind of a key element. And then finally, what is the net evaluation of a merger? Once we kind of take all these things into account, all the various aspects, where do we end up? Okay? And I think the guidelines would benefit from having a very clear discussion of these are the questions that we need to answer. Okay? Now we can talk about how we're thinking of looking at them, but we need to establish that as that's the why. This is why we're worried, and that's kind of what we want to answer in our investigation. Okay, so that's the second point. So let me finally conclude, and this goes a little bit more into details, is the guidelines need to be more specific about what it is that the agencies are going to look at. And this is important both for outsiders as you come in to sort of know what is it that we're going to be facing. But it's actually, I mean, there's another point that wasn't mentioned, I think, in the previous panel, which is it also sometimes is used as an internal guidance. Okay, I can tell you for a fact on the horizontal merger guidelines, both when I was at DOJ and working with the DOJ as an expert, you go back and use them as a reference and say, okay, what do the guidelines say? Okay? And there's a certain depth to the horizontal merger guidelines that really sort of, you say, oh, that sense, okay, what exactly does it mean? What do we look at? What should we do? And we need to have that. Even if we don't have the answers, at least we need to sort of pose what the question. There's an old Hebrew saying says that a good question is half an answer. So if we only get half the way there and pose the right questions, I think we'll get half the way there, which is a very long way. Let me stop here.
The agencies, thank you. Thank you for getting the guidelines out. I mean, antitrust these days with respect to vertical and exclusion, we're somewhat of a dysfunctional family, and so being able to get a draft out is really a big deal. What I want to do, by the way, I have a slide, if you could put this next one. I put together some slides. My view is I want to follow what Aviv said. I want to try to explain the economics to the lawyers. So my comments are going to be very concrete. As many of you know, I've issued my own suggested revision to the guidelines. I think it's a good way to translate the suggestions and recommendations that my co-authors and I made into something very concrete for people to consider. So I want to make 6 basic points. One, and this was John Sallet said this as well, the enforcement standard should be reasonable probability of competitive harm. That reflects the incipiency standard. It's quite clear at this point that the empirical evidence on vertical mergers does not support loose enforcement. And I'd refer to you to Fiona Scott Morton's comments, but also Margaret Slade's most recent discussion paper. Second, vertical mergers aren't different. They raise inherent horizontal concerns just like horizontal mergers. The unilateral effect from input foreclosure involves essentially reducing head-to-head competition between the downstream merging firm and its rivals. And you can take a look at the comment I did with Serge Moresi on this, and I'll talk more about that later. And of course, the coordination concerns are really exactly the same in horizontal and vertical mergers. Okay? Second point, the guidelines should include a full list of competitive harm concerns, including examples. With that in mind, I mean, this horizontal vertical, I agree, mergers can be both, and both aspects should be analyzed. And in my own analysis, I've found that when you've got both, the vertical and the horizontal concerns tend to reinforce each other. The agencies tend to look just at horizontal given a choice, and they commit false negatives as a result. Two poster children, Live Nation Ticketmaster would be one, where they focused on the horizontal, tended to ignore the vertical, and of course the Premdor CMC merger that the DOJ cleared in 2012, and private litigation stopped the merger last year. Third, I delete the safe harbor, but flag conditions where the merger raises heightened versus lessened concerns. I'd like to see anti-competitive presumptions, but you know, I think it's more important for the guidelines to express heightened versus lessened concerns. And I certainly think it's premature to put in a safe harbor at this point, just at the point where you're putting out new guidelines. The idea that, well, we need the guidelines to correspond to experience, well, that doesn't make sense, where the experience is that the agencies have been too permissive with respect to vertical mergers. Fourth, I think you need to clarify the concept of related product, which tends to lead to what is essentially a market, too broad a market, but without the name. The related product should focus on the suppliers of the actual and potential competitors that are foreclosed, not necessarily all the downstream firms. And I'll provide some examples of that later. Fifth, it will not surprise you to know that I think that EDM should be explicitly restructured as an efficiency benefit that regarding elimination of free riding, and it should be combined with the other efficiency section. And the burden should be on the parties to show that it's cognizable. Sufficient EDM is not inevitable. There are impediments. John Jacobson, being a good litigator, may say with great force that it's always going to occur when they had a previous relationship, so he supplies great force but no evidence. And so the question is, what does the evidence show? Finally, I would not require quantification of harms. Quantification is surely relevant. It has a place, but it fundamentally raises the burden on the agencies. It's not required by the case law, and it will tend to lead to false negatives. You can also, we economists can only quantify certain effects. Bob Major stressed the idea we're really good at price effects. We're not so good at quantifying either coordinated effects, innovation, potential competition effects. So those are the changes that I would see in revised guidelines. Thank you.
Thank you. Charlotte?
Great. Well, I agree with a lot of what has been said by the professors to my left, but a few things to add. Of course, I absolutely agree that we need new guidelines, and I really commend this effort. I'm so glad that we are beginning this project now. But I do think there's a lot more work to do to make the guidelines more useful, so that's what we're working on today, and I'm really glad to be a part of it. The thing I want to focus on in my comments is the need for anti-competitive presumptions in the guidelines. I think that would really make the guidelines much more useful for all of the stakeholders that we're targeting with these guidelines. Of course, it's simpler to have anti-competitive presumptions in horizontal mergers. We have HHIs and market shares that are much stronger indicators of the anti-competitive effects of mergers. But I think it is still particularly important, perhaps more important, in the context of vertical mergers because they are more complex. there are still some market structures where particular types of mergers are concerning to us in vertical mergers. So I think that is a key place to have anti-competitive presumptions. This will help the agencies bring cases more quickly, more efficiently, and more easily. It will help parties make decisions also more efficiently and more easily. But I think another really powerful reason to have anti-competitive presumptions is as a signal to the market so that we don't have as many of these mergers coming through the agencies that should not have left the boardroom. I think that will be a really important impact of being very clear in these guidelines about the types of mergers that we're particularly concerned about, which will save agency resources. It was also discussed briefly in the last panel that these guidelines are also guidance to judges. I think that's a really important role where anti-competitive presumptions can help. I think judges sometimes seem to bristle at having economists, expert economists, tell them what to do. So having these guidelines that are very clear about the types of market structures we're concerned about, I think will really help so that we don't end up in situations where judges are relying on CEOs to promise that even though the economics predict a company in my position will do this, we're just mavericks by nature. Don't trust those economics. I think having guidelines to refer back to will be really helpful for judges in that type of situation, which is something we've seen recently. Last, on anti-competitive presumptions, I do think we want to be careful of having an imbalance. Right now, there is a safe harbor in the draft guidelines, and there are no anti-competitive presumptions. I don't want the guidelines to be seen as taking a position that over-enforcement is more concerning than under-enforcement. I actually think that under-enforcement is often more concerning than over-enforcement, and I think we have some recent economics showing that that consumers are that under-enforcement has been more costly to consumers in recent years. And as folks have mentioned before, the Clayton Act has an incipiency standard, so I think that indicates to us that we should not be more concerned about over-enforcement than under-enforcement, and I don't want the guidelines to be sending that message by having a safe harbor and no anti-competitive presumptions. The last point I want to make, separate from anti-competitive presumptions, is I think it will be really important for the FTC and DOJ to have a second comment period after this workshop. After these two workshops. I really appreciate that there was an extension in the first comment period and that these workshops are happening. I think that takes seriously this task that we're taking on here, but it was still a very short time for folks to submit comments, and I think, especially in the nonprofit world where I'm coming from, there are more folks who would be interested to participate in this important process if we could have more time to hear from those important stakeholders.
Thank you. And Avery, last but not least.
Thanks very much. My co-panelists have done a fine job of explicating lots of the issues in these vertical merger guidelines. So I want to take a step back and maybe widen the aperture for just a moment. For the first time in 35 years, we have new draft guidelines on vertical mergers. I think that's great, and I give the agencies credit for recognizing the need for this updated guidance. But to take that step back, why do we have merger guidelines at all? And let me break that down further to why merger enforcement and why guidelines. The reason, of course, that we have a role for government in merger analysis is to protect consumers. We have an incipiency standard that talks about the likelihood of substantial harm to competition. Encoded in the statutory language is the notion that we don't know with certainty what the future holds for most markets. And Congress made the judgment call that stopping mergers that may be anti-competitive is more important than having certainty about future economic conditions. And of course, the agencies agree with this, as the Assistant Attorney General reaffirmed in his opening remarks. So if the role for government in mergers is to prevent bad things from happening, it seems to me that the role of the vertical merger guidelines should be to offer guidance to companies, consumer advocates, and the antitrust bar, as well as other parts of government, about when the expert agencies think vertical mergers are most likely to harm consumers. And on that score, I think these draft guidelines fall short. Let me touch briefly on a couple of areas. First, I focus on tech issues in my job, and we have some really hairy questions to try to figure out on vertical mergers in the tech space. All of that's getting a ton of attention in public debate on Capitol Hill, in the presidential debates. And these guidelines don't yet tackle some of the questions that I would suggest would be beneficial if they would. For example, what do the agencies think are the best measures for power in emerging tech markets, where nascent firms may have few users or zero revenues? Do winner-take-all issues in digital platforms raise particular vertical merger concerns? How do the agencies define upstream and downstream in data-driven sectors? When is data an input that may raise foreclosure concerns? And do the agencies consider data privacy and data protection issues as antitrust relevant in vertical merger analysis? So, second, there are relatively few cases on vertical mergers, and I know that the agencies continue to worry about squandering scarce resources on merger enforcement cases that may not succeed in the courts, especially given the increasing judicial demand for dollars and cents certainty in a crystal ball world. So what do we do about that? Well, these merger guidelines could be improved, I would argue, and the agencies could help the courts significantly by imbuing the draft guidelines with the right legal standard, that incipiency standard about likely harm. There are a number of places where the draft guidelines talk about certainty, where I think likelihood would be the better language. For example, they address evidence of adverse competitive effects. That suggests there has to be certainty. The foreclosure section lays out a four-part test and says mergers for which each of these conditions are met potentially raise concerns. I would change that language. I would change are met to something like are likely or may be present to, again, address that notion of the incipiency standard. Same with a vertical merger may diminish competition by making it profitable for the merged firm to foreclose rivals. I'd tweak that to say may be likely to diminish competition. So I think the draft guidelines would be strengthened if we were careful to imbue them with that incipiency standard, whereas now they may read more like requiring certainty along a number of different dimensions. I think that as a side note, the old guidelines were labeled the non-horizontal merger guidelines, and these are labeled the vertical merger guidelines. For the reasons that other panelists have said, I'm not a huge fan of trying to characterize complex business deals on two-dimensional axes, but if the agencies are trying to tell us something by changing the title from non-horizontal to vertical, I hope they'll say so explicitly and then get started on guidance for consumer advocates, the bar, and the Hill for how they figure out which mergers that don't fit neatly into those boxes may raise a likelihood of consumer harm and thus potentially warrant challenge. Finally, I want to emphasize how important it is that we get these guidelines right. We have an increasingly consolidating economy, with companies eager to get a larger share of Americans' wallets, with mergers that may lock in consumers, tie up data, and gobble up more of the attention economy. I think that most of those mergers are likely benign, and that the enforcement record at the agencies is consistent with that. But merger enforcement is our chance to stop anti-competitive deals before they harm consumers and damage markets. In an increasingly fast-paced world where tech and consumer wants change faster than ever, we need a common understanding among antitrust experts on all sides of the debate about when vertical mergers are likely to harm consumers. More detailed guidelines from the agencies covering more topics would inform that debate in a very powerful way, and I hope the revised guidelines put a little more meat, plant a few more trees in our forest. Thank you.
Thank you. And in many of your comments, you talked about sort of the legal background here, the horizontal and the vertical deals. So maybe one discussion question to kick it off with is, are there differences in the doctrinal approach to vertical and horizontal mergers that should be reflected in the vertical merger guidelines or not? Could we kick it off with you, Professor Yu?
Well, thank you very much. The doctrinal question is actually a really tough one because As all of us know, there's been a relative lack of development in actual law. The development of the guidelines as a guidance of enforcement practice has made the game quite different. If a challenge is brought, mergers are typically abandoned, and the number of litigated cases has become vanishingly small. We have the benefit of the AT&T Time Warner merger being the first significant litigation in the vertical case in quite some time. And I find some really striking things about this. One is that there is a discipline where they insisted that concepts such as must-have content aren't just slogans, they actually had to be analyzed and defended. And it can't simply be that it would be better for one of the parties to have a certain access to a particular input, or they're disputing over price, which is a routine disputes over price is absolutely something antitrust should not get involved in. And they started to insist on actually moving to theories, and we saw evidence based on how the economic evidence was accepted. It tended to discount stylized theoretical models by looking sharply at the parameters used to make them actually show the kinds of harms and to take a critical look at where they came from. But at the same time, they did the courts gave credit to large and retrospective studies on 4 recent vertical mergers in the space to look on a more empirical basis what the net effects are. And this becomes critically important in a vertical merger because there's multiple theories, all of which, many of which point in different directions. And all of them are stylized reductions of reality. And what you often will find is all the theories have a certain amount of validity, and it's really a question of what the net cumulative effect of them are pointing in different directions is. And I think that is an interesting development in terms of actually what that law is teaching us. I do think that there's a difference in the basic, we look at the empirical evidence is framing this. We may not always have the benefits of a space where we have had 4 similar or at least relatively similar vertical mergers between a multi-channel video provider and a network to look at. We may have to look at the broader empirical base in looking at things. I do think I agree with Aviv and the comments I made earlier. We all could wish for a thicker vertical empirical literature than we have. It's helpful. I think it's telling and based on how people have assessed it, but I think we understand that it could be I think what Commissioner Wilson called it a deafening silence, I think appropriately that there's more that we could have here. The one thing I do worry about is, one thing I do agree with Commissioner Wilson is I would follow the old guidelines example. I do think that empirical evidence is strong enough to say to restore the 84 guidelines statement that's been picked up by the EU that vertical mergers raise fewer concerns. And I think that statement is at that level is true because the literature on horizontal beyond certain levels is much more uniform. Here is a dispute about whether it's mixed or tends to favor pro-competitiveness, and there's a bunch of surveys going to that issue. There is another, just to throw one other thought out there that's also actually not terribly economic, but I'm always reminded by a quote, I heard it most recently from Angela Merkel, but it's not hers, and as she would note, she was asked what's the difference between innovation policy in the US and in the EU? And she said, in the US, everything that's not forbidden is permitted. In the EU, everything that's not permitted is forbidden. And to me, there's something telling about that with respect to new practices, because by definition with new practices, whoever bears the burden of proof is going to face a huge burden, because if it's new, there is no evidence you can show. And I worry that blocking practices in the absence of any evidence of harm does pose a risk to trying things that have never been tried before, which could put a drag on innovation. And so there is a different, people have talked about the lack of innovation being taken into account, something both Avery and Steve have mentioned. There is a consideration that in the absence of demonstrated harm, that there's a significant benefit to allowing people to experiment with new practices. Otherwise, you could have antitrust law being a brake which tends to be inherently conservative and may stop the driver of innovation that we've enjoyed so much for the last, certainly last 30 years, if not longer.
Let me respond and make a couple points myself. First of all, you're also wanting to put a huge burden of proof on new enforcement practices. So that door swings both ways, as well as the fact that, wait, are we looking to the EU for antitrust leadership now? Is that the new conservative position? That's That's really new. Google search, Android, we going to follow them there too? Or are we going to follow Merkel and saying if it's not shown to be good, it's forbidden? I think we got to go our own way on this one, just as we have in every other area of antitrust. With respect to the doctrine, there has been some development, and I find it really interesting. The thing about EDM is, as somebody said earlier, it's not a real, quote, real resource savings. I think Bob said it. Instead, it's a change in incentives. And fundamentally, EDM is internalization of a free rider problem. The two merging firms, instead of free riding on each other, they begin to take the benefit, each division takes the benefits to the other division into account. And we have a Supreme Court case on free riding incentives. In Legion, the Supreme Court treated elimination of free riding as an efficiency benefit, just like all other efficiency benefits. And the Supreme Court in Legion did not adopt a pro-competitive presumption for intra-brand restraints. Instead, it adopted the conventional rule of reason. And in the conventional rule of reason, the burden to show efficiencies is placed on the parties, not on the government. So to the extent we have doctrine, in addition to Brown Shoe, Ford Autolite, and AT&T, we also have Legion.
So we'll get into this a little bit more later, I think, but like Avery, I also focus on the tech industry, and we are dealing with, in that industry, firms that markets that tend towards tipping, where there is largely competition for monopoly rather than dynamic ongoing competition between multiple firms. And in that type of situation, I think we need to be very careful about allowing mergers. It can be very hard to fix a mistake if we allow a merger through. Because competition is so rare in those industries, if the potential competitor can be purchased and taken out, there may not be another one for a long time. So that's sort of perhaps a different situation, but may come up in more industries than I am as familiar with, where I think we really do need to be a little bit more towards what Professor Yu has described as the European model, in being careful not to make that type of mistake.
Just one quick point on the doctrinal question that I was thinking about last night, and that is that yesterday we got our first arbitration decision in a merger matter for a very long time, maybe ever. And I think it'll be interesting to think through how the guidelines affect arbitrations if we go forward with more of those from the agencies in a way that's different from how courts have handled them, and what that implies for how we think about guidelines and the guidance that they should give not just to the merging parties, consumer advocates, and judges, but also to potential arbitrators in cases like that. I also note that the arbitration opinion is very, very short compared to your typical merger opinion. At least I was pleased not to be slogging through another 137 pages, as often happens. So I don't have an answer for that, but I think it's something we should keep our eye on. If there are more arbitrated merger cases, what does that imply for the kinds of guidelines we want to be issuing?
So if I could just kind of weigh in. So I'm obviously not going to weigh in on sort of what the current case law is or what the current legal approach is. But I do want to say, and this actually goes back to a comment I made, or a couple of comments I made earlier, I think an important part of the guidelines is actually to be forward-looking and not just sort of say this is what courts have been doing and what the legal framework is, but what should the legal framework be? Okay, so in some sense, saying not what are courts doing, but what should they be doing? And that is, again, I think the role of kind of economics to kind of try to shine the light. And I think this kind of relates back to a comment that I made before, is that vertical mergers and horizontal mergers actually share a lot. They probably share, more than if you start separating and say, okay, we have guidelines, we have a framework for one and a framework for another, would lead you to sort of think otherwise. I mean, in horizontal mergers, it really is about internalizing, kind of, if you want a negative, if you have substitutes, a merger between substitutes, a negative externality that they impose on each other, and that creates, the upward pricing pressure. To some extent, your plain vanilla vertical theories have that same effect, except that now the internalization is between, if you want, vertical silos, right? That's kind of the effect that, that you would get. And, if you know sort of Steve's work on the various vertical guppies, that's ways to quantify some of these effects, very much like the horizontal.
We quantified the EDM effect in the vertical guppies.
Sorry?
We quantified the EDM
I know,
effect.
I'm actually, I didn't say you didn't. I said you quantify. I focused on other effects. So there's a lot of overlap between these, and I think going to a world where we're going to start labeling, we have a vertical merger, and we're going to do one thing, we have horizontal, and we're going to do another thing, and whether or not courts do that, I think it's important for the guidelines for the agency to say, no, that's not the right way to look at it. The right way to look at it is look at what's common, look at what the common economics are, and yes, there are things that are different or potentially different about vertical mergers, and let's look at them in a case-by-case basis, just like we do in horizontal mergers.
So, oh, did you have another call?
Just want to put in an ad for the paper I wrote with Serge Moresi, the comment we put in. We actually showed that the negative externality that Aviv referred to, you can translate that into, in effect, an increase in a effective concentration. We estimated what we call a proxy increase in the HHI. So you might find that interesting to show how vertical leads to horizontal.
So one of the most discussed aspects of the guidelines is whether or not there should be a safe harbor provision. So following up on that, I'd like to ask kind of two questions. So the first one is, if there's going to be a safe harbor, does it need to reflect a number taken that's drawn from kind of the existing economics literature on vertical mergers, or can it reflect broader kinds of agency experience? And then the second question is, if there is going to be something like a 20% threshold number in the guidelines, should that be inserted into a section on anti-competitive harms where, for example, it might discuss how the shares relate to substitutability or availability or substitutes? Or should it be in a separate section of the guidelines where it says, overall, this is how we're going to think about a particular transaction? So Aviv, I think you can comment on this.
Okay, so let me start. Those were a couple of pretty long questions and slightly different than the ones we discussed earlier, so maybe my answer won't completely align with your questions. So first, I guess there's, and this is more, I guess, than a comment on or an answer to your question, but more kind of the discussion early on. There is a big, question as to whether the 20%, and you can, there's a couple of 20% in there, in the guideline really is a safe harbor. I think the guidelines sort of go out of their way to sort of say they're not, or maybe they are, but no, they're not. So it's not clear, if they are or they're not, and my guess is it's going to stay unclear, but I assume if there's going to be a 20% number, everyone's going to treat it as a safe harbor, whether it is or not. There's a question of whether it should be. So, I get the arguments, even though I think maybe as an economist I shouldn't, but I do get the arguments why having a clear safe harbor has some benefits. I mean, you want to sort of give, you want to be able to give, guidance or as clear guidance as you can. But the problem is that, yes, we want to do things. There's a lot of things I would like to do and I can't. Maybe I won't give examples for webcasts, so maybe they're not going to pass the appropriate rating. There's a lot of things I'd like to do and I can't. And yes, we'd like to give clarity, and we'd like to say, look, there's a clear cut. You're okay, below that. You're not okay below that. Although it's not a clear cut, but yeah, you're okay. But sometimes we can't. Okay, I mean, this goes back to kind of various points that we made. Maybe we're still, the theory isn't quite as clean cut as we'd like it to be, and the empirical evidence isn't quite there. And maybe it's better to sort of say, and this goes back to kind of the vagueness, the likeliness. Maybe we need to make something that's, even though we'd like to give something that's as clear as we can, it's just not going to be there. And maybe it's better to articulate a principle of what it is that we're trying to do and say, in many cases, it seems like with 20% you'll satisfy this, but maybe not. And I'm just taking the language that's in the 20% that's there. But going beyond that, is share the right measure? Probably not. Again, it's both share in terms of, and in some sense, shares never really are the right measure, even when we talk about horizontal mergers. But there may be a good approximation. I would have preferred that, again, even if you're going to have a share, at least articulate what it is that the share is trying to capture. What is the principle that we're worried about, right? And in the case of, if we're looking at the share in the relevant market, the kind of the first part of the 20%, there what we're really trying to get is the incentive component, kind of the second element, the second question that I had earlier on. And I think it's important to articulate that. And again, that would give the kind of fuzziness that comes along with it, the measure kind of a little bit more concreteness of saying this is the discussion we need to have, and we can talk about whether 20% is the right measure in a particular industry or not, or whatever the measure is, is it 20 or anything else. So I think that's much more important. Now, where is it good to have that discussion? And by the way, before saying where it's good to have that, I particularly kind of worry about the 20% in the extent that it talks about the 20% of the related product or the usage of it. And again, this was some discussion. I think Bob gave a very good example in the first panel of the measurement issues that are involved with that, right? The AT&T example of is it 20% or is it 100%? Which is kind of the right measure. How do we get to a 20%? Okay, what is kind of, what is the mark? How do we measure it? Where do we get, where's that number coming from? And again, I think it's much better to discuss what are the economics and what are the principles of it. Now, if you're going to that approach of saying what are the economics and what are the principles, there is a question then, and this goes back to your question of whether it should be a part of the harm. It might be a much more natural place to talk about it when we're talking in the context of here's what we're trying to achieve. Although I do worry if we're going to start having, in the concept of the harm, say, okay, we're going to have, here's a threshold that we use if the theory is a raising rival cost. If we have some other theory, we had a long list of them on the slides kind of before. If we're using some other theory, maybe we're using some other threshold. So I think you have to kind of balance finding something that's general enough, that looks enough at the forest, but gives enough trees.
Does anyone else on the panel have comments?
Yeah, I'll comment. I have a slide on this? I've got, yeah, that's it. No, the previous one. So I want to take an economic approach to the question of the safe harbor. And the economic approach is that the 20% share thresholds makes no economic sense. And I've provided 3 examples that are in my suggested guidelines and are here. The first one, this example A, if you read it, the reason 20% fails is it ignores the fact that when the upstream merging firm, which I call U1, raises its price, that induces U2, the Frankenstein monster, to accommodate the price increase. And when they both raise prices, then everyone's costs are raised, and that can lead to downstream harm. So this is a really simple example. I want to note, contrary to John Jacobson's slide earlier, there's not always one Frankenstein monster. These Frankenstein monsters, they run in groups. You normally have plural Frankenstein monsters, and the simple idea is that it comes from a unilateral merger effect. If you have a merger of firm 1 and firm 2, and they raise their price, you will tend to have firm 3, firm 4, and firm 5 raise their prices, accommodate that price increase in response. We call that the multilateral effect, or parallel accommodating conduct in horizontal, and it applies to vertical too. Second example, the upstream firms are small, but 2 of the downstream firms can only use the input provided by a couple of upstream firms, U1 and U2. So when U1 raises its price, it doesn't have to worry about what U3, U4, U5, and so on are doing. If it raises the price, U2, which is its closest competitor, will raise its price. Again, very common when you have differentiated products, when you've got switching costs, you can have the situation where there are narrower sub-markets or narrower antitrust markets. And then the third example is coordinated effects. If the upstream merging firm is a maverick with only a 15%, say, market share, or if the downstream merging firm is a disruptive buyer, in either of those situations, they could be disrupting upstream coordination in the pre-merger world, but they would not have an incentive to do so in the post-merger world. So that's a problem with the 20%. It would make more sense if you were going to have a safe harbor to base it on concentration levels, but of course we don't. These things could occur even if the markets have pre-merger low concentration. You'd like to have a delta HHI like we have in horizontal. As I mentioned, Serge and I have come up with a delta HHI if you wanted to base it on that.
So it's interesting. I kind of agree with both of you, if that's possible, both Aviv and Steve. I think you're both getting at some things that are very important. Consistent with what I'm saying earlier, in a sense, what's my concern about the safe harbor is it's really untied to any theory. And I think what a consistent thread we're hearing in some of the comments I've read and some of the things we're seeing here, the problem with vertical is you have a wealth of theories. And for example, there's dominant firm ones that require extremely large market shares for which 20% is really an inappropriately low benchmark if that's the theory you're proceeding under. The multilateral effects that Steve points out would be very different. And what we really need to do is to think through them in that context to try to figure them out. And what I find is the tendency is to skip through that to say it's possible that a small market share could lead to that on a certain theory, therefore all vertical mergers are suspect. I actually think that, it's sort of when, yes, if this is considered a burden on innovative enforcement, so be it. I think Aviv's initial setup is the orthodoxy of a lot of vertical enforcement, which is the typical merger case or competition law case. You have to show the ability to affect the conduct that's in question, the incentive to do so, and you have to do some assessment of the net effects. And that's as plain vanilla as I know this to be. And so all of the safe harbor stuff should be folded into this analysis. The logical safe harbor is if there's a percentage below which no theory can state a vertical case, then that's on a pure theory basis you can assert a basis for a safe harbor. And to me, that's a conversation I'd like to have to looking at tying it to specific theories. But that's really the motivating question. On the other hand, we don't want it to be that, okay, the fact that you're above whatever safe harbor set, if one is set, makes the merger suspect is also a misreading because you have to tie it to a specific theory that shows the ability, incentive, and effects in the way that we're all very familiar with. Avery?
So just very briefly, I was a practicing lawyer for many years at DOJ and then in private practice, and I will say that having some guidance that you can turn to that says 20% is probably going to be a level below which we're okay is incredibly helpful to the bar. And so I agree with my economist colleagues, all of them, with all their varied opinions, that 20% maybe is right, maybe is wrong, I don't know, it's a little tricky, depends on the theory, it's hard. But I will say that this is not a safe harbor. It is giving guidance. And in that, I think it's actually very good that the agencies have said, look, below 20%, it's relatively unlikely to raise these kinds of concerns. And it reminds me a bit of the Business Review Letter standard that says at the end of the day, look, based on the facts we know, we don't currently have a present intention to sue you. If things go funny or weird or unexpected, we can take that back, and we're not saying we're bound by this. And that's the way I read this 20%. It says, look, we're trying to give you guys some guidance that you can actually explain to a client, or you could explain to a policymaker. And is 20% the right number? I defer to the economists on that. But the principle of having some guidance, I think, is very helpful, and I commend the agencies for trying.
So just to briefly reiterate my point from the beginning, I think that there is a real imbalance in having a safe harbor without any anti-competitive presumptions. And I think that sends the wrong message about how we feel about vertical mergers.
So now turning to EDM. So should there be a presumption in favor of EDM that runs to the parties' benefits, or should the parties bear the burden of showing EDM will take place? Also, what is the correct comparison for whether EDM is really merger specific? in the sense, should we be assessing whether it would be likely to happen if the transaction is blocked, or should the standard be what the parties could possibly achieve through contracts? Steve?
Yeah, let me first focus on the first question, which is the economic question. I do not think the EDM should be treated as presumptively beneficial. And I think all the claims that are made in favor of giving EDM this special status don't make economic sense. So let me go through them. The first is that it's said that EDM involves incentives, not production efficiency. And I already addressed that. Whether it's incentives or production efficiency, it's still something that generates downward pricing pressure and should be treated like other efficiencies. Secondly, it is said, and this is the main one, that EDM is somehow inherent in economic models. And Bob Major killed that one in his remarks. Well, it's in some economic models, but not in others. I've given a couple examples on the slide. In the Hart and Tirole model, there's no EDM. There's raising Reynolds cost and no EDM, and they both won Nobel Prizes. There's in the OSS input foreclosure model, the upstream firm's not a monopolist. There's accommodating price increases. There's no EDM, but there is raising Reynolds costs. And OSS did not win any Nobel Prizes. In the Knock and White coordinated effects models, there's potentially EDM, but they find that coordination increases, and as a result, prices don't go down, prices go up. So it's just not true that you can rely on the Spengler model from the 1960s to say that EDM is inherent in economic models. Nor is EDM inevitable in the real world. There's no reason to think that EDM benefits would be sufficient to offset the raising rivals costs or coordinated effects harms. Let me give examples. First of all, there's a fundamental upward pricing pressure from a vertical merger that was first identified by an economist by Chen, and it's one of the vertical guppies in Moresi and Salop. The downstream merging firm raises price knowing that it's going to lose customers to the other downstream firms who will then buy more inputs from the upstream merging firms. And so that's an upward pricing pressure incentive. That's actually in the draft guidelines, though you may not have noticed it. Secondly, Hart and Tirole and OSS both have very low pre-merger margins. So there's no EDM because the pre-merger margin's low, but yet there's raising rivals costs. Knock and White I already talked about. EDM could often be achieved by contracts. That's COSA's big insight. Again, another Nobel Prize. Now, getting down a little more concretely, sometimes inputs are incompatible. Sometimes there's switching costs or other costs that would deter internal transfers. And so you would not get EDM. John Jacobson referred to diagonal mergers having that effect. The empirical literature is really clear. And using a very large database, an economist named Adelaide and some co-authors had looked at a huge number of vertically integrated firms, and half of them did not transfer any assets from their upstream division to the downstream division. Okay? Next, firms may structure themselves so that they tell their divisions to treat each other at arm's length. And if you have that, then you're not going to get EDM. And there's an important paper by Bonanno and Vickers and other people. Finally, EDM is going to be limited if there's limited capacity or rising marginal costs, or if downstream demand is inelastic. Okay? As for merger specificity, yeah, it's a matter of fact, like John Sallet said. The John Jacobson approach of simply shouting bargaining frictions at the meeting, that's not proof. There really ought to be proof, and the burden should be on the merging firms. There's a lot of things they might show. John Sallet said you don't need to show everything, but you need to have some evidence. What kind of evidence? Well, we tried to negotiate, the negotiations failed. Other firms are also unable to, none of them have internalized EDM, and so we're not the only ones. Well, it'd be even stronger if they could show we couldn't do it here, but we've internalized EDM internally. We're vertically integrated in some inputs, and there we do internalize the EDM, and we sell some complementary products, and we internalize the equivalent of EDM there, and we sell some substitute products, and where they're substitutes, we price them taking into account that if the one substitute loses business, they'll lose to the other, and we charge higher prices as a result. So the firm can just show that they're cognizant of the idea and they take it into account. Finally, if the impediment is an anti-competitive agreement, or if they haven't gotten rid of EDM in the pre-merger world because they're coordinating, then that shouldn't be credited. And I think that's really relevant for AT&T Time Warner. I mean, I thought a lot about why they didn't internalize EDM in AT&T Time Warner on the assumption that they didn't. And the best explanation I've come up with is that there's a web of most favored nation provisions in the cable industry. And so they couldn't deviate, they couldn't give a discount because it would have had to spread to all the other firms. But if that's true, then the MFNs were anti-competitive. I mean, you shouldn't allow the existence of an anti-competitive agreements to justify a merger. That doesn't make any sense. What the government ought to do is go after the MFNs, to go after the anti-competitive agreements. So those are all the reasons. One more remark here. To the extent that EDM is an out-of-market efficiency, for example, suppose the anti-competitive harm that's found, not just theorized, but found, is upstream coordination, well, you should not allow EDM in the downstream market to say that, well, consumers benefited, but there was coordination. That should not be permissible. That would be an out-of-market efficiency in the horizontal merger guidelines.
So can I ask about this, thinking through how this might look in an investigation, the negotiation attempted and failure occurred element here. So, imagine we send a second request, we get the custodian who's the EVP of contracting, we find that he spent 6 months negotiating a contract, a supply agreement with all sorts of bells and whistles in it. If the resulting contract does not itself eliminate double marginalization, is that alone evidence that they're unable to do so? Or do we need to find an email in there that says, hey, Fred, what about EDM? Can we come up with a way to do that on Tuesday? And then they come out of the Tuesday meeting and they weren't able to do it.
First of all, if they eliminated some of the EDM, that becomes the base. You only get to count the rest. But yeah, if they eliminated some but not all, you might imagine that, assuming there was no coordination incentive, which there often is, that they were afraid if we cut the price by more, it would spread, and in the end, we'd end up with lower margins for everybody. If you get rid of that, then yeah, that shows something. But you know what? In the experience is you guys never ask. You guys just assume it. I mean, I worked on a merger a couple years ago in which, I obviously can't name the names, and the merger would not have been anti-competitive anyway, but they were in the midst of negotiating a lower price. And instead, that was the divisional guys, were in the midst of negotiating a lower price, but then the corporate guys decided to have a merger. And we were just dreading the idea for when the agency would ask us, were you negotiating? But of course, they never asked. All we needed to do was have the lawyers whisper the words, elimination of double marginalization, and the agencies were convinced that the deal was fine.
Would anyone else like to comment on these issues?
So I'll just comment briefly. So just to kind of pile on, I mean, Bob said it earlier, Steve sort of has it on the slide. There were comments made before that, EDM exists in all models. That's, if maybe there's a few things we can say with certainty today, that is one that we say that is wrong. Okay, I mean, Bob, as Steve said, Bob knocked it out of the park earlier. Steve, I think, continue hitting on the head. Let me stomp on, that, what hopefully is that dead claim. It typically exists in models of linear pricing. I say typically because I'm not even sure if that, even in all those models, it always exists. And linear pricing might or might not actually be a feature of an industry. I mean, it's definitely a feature of a lot of our models. Because again, as Bob alluded to earlier, it's mathematically very easy to work with. And you know, if you're an academic, you want to publish papers, you want ones that you can actually get results, as opposed to saying, oh, you know, it could go this way, it could go that way, I don't know. Doesn't do well for publishing papers. But that doesn't mean that models like that are used, again, for mathematical simplicity, should actually be used to make, you know, general claims. So that's the first point. The second point is just to kind of, if you want to pile on and agree, again, what was said before, in my view, EDM should be evaluated as part of efficiencies. Now, you could sort of say, look, from an economist's point of view, it's saying all that you're doing is saying, instead of having a section 6 in the draft guidelines, maybe it should be section 8.1. Okay, and maybe that's, you know, from an economics point of view, maybe that's all we need. But of course, you know, now we're going to kind of legal questions of who carries the burden, and if it's section 6, it's one party. If it's section 8.1, it's another party. You know, again, I'll leave that for the lawyers to argue over. But I think from a pure kind of economic perspective, it really should be under the efficiency. You could say the difference from other efficiencies is that in many mergers, or some could say all, some could say some could say, you know, whatever fraction, it's kind of a quote-unquote built-in efficiency. Maybe, maybe not. Depends on the circumstances, and then maybe should actually get, and it should get, special treatment under efficiencies. But I think from an economic perspective, that's where it belongs.
So I think I agree with what Bob had said, and Steve and Aviv, that RRC is not in every model. EDM is not in every model, but I wouldn't, just to take what I'm saying, it is in some models. You know, and to say that it's, I don't want to overread that. I don't think anyone in this room is going to make that mistake, but just to make that clear. I mean, I was just thinking, there is an explicit disclaimer in Michael Winston's famous tying model, and if we're counting, he is a Nobel laureate, where he says, look, this, I'm not claiming, I'm looking at an incentive effect. I'm not actually looking at anything about the efficiencies. And he notes the market is structured in a way that tends to give rise to these sorts of things. And to pick another person who's not a Nobel laureate, but is a former head of the Bureau of Economics of the FTC, Michael Salinger, his famous vertical integration model does build it in. And so, I mean, there are examples where this is going to be relevant. What's interesting to me is Steve's characterization of saying it's an out-of-market efficiency. It's going to put us into the question raised by Commissioner Wilson and some others about whether we want to focus on the net price effects to consumers at the end, or whether you want to look at the impact on the input market separately. Because if you look at a consumer's impact in the end, it's not necessarily an out-of-market efficiency. And then you start to understand why the guidelines about have been structured the way they are. You can start to think of it instead of as a price effect that should be taken into account up front. And it was mentioned in the last panel, I wish I could attribute it to the specific person, that there's efficiencies of a certain way of cost reductions. This isn't really a cost reduction. This is a change in a classic price theoretic way of the incentives that happen. And the question is, if efficiencies are really for cost reductions, it sort of belongs down there. The last comment about merger specificity, we have comments from LaFontaine and Slade, Francine LaFontaine and Margaret Slade at the FTC hearings, from Commissioner Wilson earlier, interviews with Joe Simons, and comments from Bob Majur earlier, that in fact it's not, it is not true generally that all things regarding vertical contract can be handled by vertical contracts and never require vertical integration. And that's generally, there's a pretty broad consensus that it's also not true that you can simply say, oh, this has to be done to vertical integration. That's something that has to be worked out in litigation to work it out. But there is a case that it's not simply the case that there's no such thing as an EDM that can always be handled by contract, and there's a pretty broad consensus to that effect.
Yeah, you should look at Margaret Slade's new paper with John Quokka called EDM, More Doubts Than We Used to Have, or some title along those lines. Margaret's also said that you can't use the empirical literature to guide antitrust policy in her other paper. What I want to say about the out-of-market efficiencies is that the guidelines dug this hole for themselves. They said they're going to define a relevant market. It might be the upstream market, it might be the downstream market. So if they define the relevant market to be the upstream market, where the concern is upstream coordination, or the concern is customer foreclosure upstream, well then the impact on consumers in the downstream market is out and out of market efficiency. That's just the way it is. So they can, they could say they're not going to bring the case because the efficiency is inextricably linked to the anti-competitive harm. They can do that within kind of the context of the horizontal merger guidelines, or they can just change the way that they're looking at it. But if they define the upstream market to be the relevant market, then the impact on consumers of the downstream firms is out of market.
Well, I actually agree with you, Steve. You're making my basic recommendation is to make anti-competitive effects really with respect to consumers, to follow the example of the 2010 merger guidelines and make that the focus. And if that's the case, all the rest of this follows. I actually agree with you that that's how we should be thinking about it, in which case I do think that's a change we can make to the guidelines that would make that clear.
But the horizontal merger guidelines also say we look at buy-side effects, which would be an effect on the upstream market, and they're quite explicit that you don't need to show benefits to the consumers or harm to the consumers in that situation.
So let me just maybe switch gears a little bit. Obviously, the guidelines are industry agnostic, but a number of our comments and a couple of people we have here mentioned they need to make sure to adequately cover big tech issues in some of that conversation we're hearing. So I guess the question is, do the guidelines as currently drafted adequately cover the issues that can arise in vertical transactions in big tech? And what would be the pros and cons of trying to add more industry-specific guidance here? Maybe we'll start with you, Charlotte.
Great, thank you. So I don't think that the guidelines currently sufficiently address big tech issues, but I don't think that we actually need to get industry specific in order to address them. I think it would be fine to do that, but my proposal doesn't require that. What we're proposing is a dominant platform presumption, and that may sound like it is targeted at big tech, but it can be other types of dominant platforms as well. Those dominant platforms are defined by network effects and economies of scale, because, as I mentioned earlier, those are the types of characteristics that lead a market to tend towards tipping. So then we expect competition for monopoly, and it becomes very difficult for competitors to get in and compete and have some competitive pressure on the dominant firm. And it's also difficult for enforcers to identify which are going to be the problematic mergers. So I think we've seen some examples of that in some of the big tech mergers that in the past that people today are really talking about, was this the right decision? I think about Facebook, Instagram, for example. One of the arguments we hear is that that was a crucial moment for Facebook, that they were making their transition to mobile, and maybe that was the key when a company that was much better at mobile, such as Instagram, could have unseated them. Some question as to whether that would be considered a horizontal or vertical merger, right, depending on the analysis that we don't have access to outside of the agencies. But it's a type of market where nascent and potential competitors may be the only sources of competitive pressure, and so it's especially important that we protect those. So the presumption that we've described, and this is in several of the comments, because it comes from Professor Salop's paper, but several different commenters have suggested it. If a dominant platform that meets this definition that I just described acquires a competitor in an adjacent market or a vertical or complementary product company that has a substantial probability of entry or a substantial probability to support competition absent the merger. So I know that's a little confusing to hear spoken aloud. So I have an example. I think the support competition absent a merger is the part that's a little confusing. What is the type of a vertical or complementary product that could support competition absent a merger? So one example that might fit this bill, although of course it depends on non-public information that I don't have, so I don't know whether this actually fits the bill or not, but thinking back to the Google-Waze merger, so Waze was maps and directions service that was similar to Google Maps that Google bought. And we have to think seriously about the potential that a company like Waze might have had. So specialized search is, of course, it's very difficult to compete against a dominant platform, but one of the ways is to begin in one vertical, such as specialized search as compared to general search, and expand out from there. So you can select particular specialized search verticals that are particularly lucrative. A lot of the searches on Google are not very lucrative. You can't really run ads on them. But something like Waze, something like local search, is a place where you can do some advertising, and it ties very nicely into a travel sort of vertical. So you can imagine maybe the ITA merger, you could imagine those companies, Waze and ITA, working together with Yelp or some other similar location service to provide not a complete competitor to Google General Search, but providing a sort of travel search option that in that one vertical provides some real competitive pressure, and that is one of the methods for competing against dominant platforms. So if we really are considering those types of possibilities and the impact that perhaps a very small merger could have, I think that would really benefit competition in dominant platforms, which is an area where we sadly do not have very much competition today, and it's a very important part of our economy. So I think that would be a really important way to improve the guidelines to deal with big tech, but does not require actually getting industry specific within the guidelines.
So I both agree and disagree with you, Charlotte, and I know we're running short on time, so let me try to be brief here. First, I think that tech is not a sector, it's a vector, and so if we try to do things that are specific for tech, we're going to run into some real problems. Second, I think the guidelines would benefit from the addition of more discussion of things that are specific to some of the issues that arise in that vector. And I'm thinking particularly about data. I mentioned whether data could be part of an input foreclosure discussion. I'd like to see some discussion of that. I don't want to go back to the EDM conversation we just had, but I do think there are questions about industries that have very low marginal costs and how that plays into some of the EDM conversation. I think where I may differ is that I don't think we're quite ready for anti-competitive presumptions in these guidelines. I'd like it to be part of the policy discussion we have as competition advocates, but I think it's really hard to define words like dominant and adjacent, and I think we need to be able to do that really, really well before we think about putting them in the guidelines. So I think we're not there yet. And I guess the fourth I would say is that I would love to have more of the examples relate to tech. You know, I really like orange juice, and I loved reading the examples about orange groves and orange juice, but those aren't the big questions and problems that we're grappling with. As advocates for consumers these days, we're thinking about issues related to the broad range of tech services and issues that we are dealing with from the minute we wake up and we first check our phones to the minute we go to bed and we check how many steps we walked. And I'd love to have more examples added to the draft that cover a lot of those issues.
I think you should do a little more because of both innovation and potential competition are both really important for tech, and they're not given enough play in the existing guidelines. You asked about pros and cons. I don't see any cons about talking more about innovation, potential competition, or tech. There's some additional drafting involved, but really that's all. You've got the talent to do that.
So if I could just jump in quickly. So I guess I'm in part agreeing and part disagreeing and everything was sort of said before. So I think one thing that shouldn't be is any sort of industry, sector, whatever you want to call high tech, anything specific of saying we're going to do enforcement differently in this industry. What's important, though, is to give general guidance. And it's important that general guidance is general enough to include cases like high tech, and this actually goes back to some of the discussion that was in the previous panel about related product or should be vertical. I think that's a perfect example where in kind of the modern high tech industry, whatever you want to call it, it's not your typical, okay, there's a guy here that sells to a guy there, right? It's really more about putting stuff together and who's the upstream, who's the downstream, it's hard to kind of put those labels and kind of, I think, ties in back. So I think that's a place where it's, I actually, not surprising, like Bob, also like the current language. And I think that might be a case where giving examples that go beyond the classical, you know, whether it's orange juice, and nothing against orange juice, going to kind of other examples would be good. And I agree with Steve, innovation, potential competition, very important topics.
So I like terms when they enlighten. I don't like them when they obscure. I don't like the term big tech. It invites you to lump together firms that are quite disparate. So the other term you hear is AFA is GAFA, and the other one is FANG. GAFA, Google and Facebook are advertising companies, one in search, the other in social networking. You can argue about whether they're different. No, those are different markets, and there's a literature on that. Amazon is an e-commerce company that does a cloud business on the side. Apple's a device company. Throw in Netflix if you go FANG, it's a subscription video distribution company. These are radically different business models. And the idea that we gain an insight by lumping them together and calling them big tech is an invitation not to do good antitrust analysis, in my opinion. So I don't like the idea of using terms. I often hear digital equals winner take all, and I think about the EU case. One of them is on travel sites. Travel is not a winner take all market. And so we actually have to understand and do the work that we need to do. And just to jump in, since it's brought up, I actually would like to agree with Avery and sort of disagree with Charlotte in one area. Anti-competitive presumptions, you know, I would go back to the basic standards of proof that Aviv laid out. You know, you look at ability, incentive, and effects. You only do presumptions when you have enough empirical evidence that you don't have to bother with all of that. You can skip all of that. And I don't think we're there yet with vertical.
Okay. So changing tack slightly in the last few minutes. So should the scope of the guidelines be expanded to explicitly deal with mergers of complements and what have been called diagonal mergers? If diagonal mergers are to be included, what type of considerations would the guidelines need to list that are not included in the current discussion of vertical transactions?
So I'm going to be brief because I also know what the last question is, and it's a good one. But the short answer to the question is yes, the guidelines should be expanded to deal with those other forms. I think the notion that you can put four-dimensional business models into two-dimensional characterizations of vertical or horizontal is silly. Most of the deals I've worked on have had horizontal, vertical, concentric, orthogonal, and circular and other aspects to them. So I think that we need to meet the M&A world and the consumer needs where they are, and that is to not define it strictly by vertical and horizontal or diagonal type descriptions. But it doesn't really matter what you call them. The key issue is identifying potential harm to consumers from mergers, right? And so it would be very helpful in such expanded guidance to include more discussion of non-price effects. I think a lot of the issues we talk about in purely horizontal mergers are often lending themselves well to good price models. I think that when we're talking about vertical or diagonal or whatever label you want to put on it, questions about innovation, questions about potential entry, questions about quality are the kinds of non-price effects that are hard to quantify, and I know my economist friends struggle with that notion, but I think the agencies are up to the task and more guidance would help there. The other is that it used to be very common for the agencies to issue closing statements when they decided not to challenge a merger. And I think that's another way of giving guidance in some of these deals that have complicated relationships about how the agencies applied whatever guidelines exist and what analysis they did in deciding not to challenge a merger. That would be another source of great guidance to the bar, to advocates, and to companies, and I would encourage you to not just beef up the guidelines, but beef up the closing statements.
Okay, so why don't we shift, I see we're running out of time, to our final questions, just so we can get through everybody, and it's the same one we asked in the last panel. You know, if you were the sole decision maker here, what's one feature of the current draft that you would absolutely change? And what's one that you'd keep the same?
So I've already talked a lot about anti-competitive presumptions. So instead for this question, I think it would be really useful to have a commentary on these guidelines. The horizontal merger guidelines have the 2006 commentary that accompanies them, and it's a series of examples from real cases. I think that would be especially helpful here. I know that we don't have as many recent litigated vertical merger cases, but going back to further back if we need, I think having that kind of commentary will really help practitioners and advocates and judges to interpret the guidelines, and I think that's a really important piece of any guideline, so I hope that we'll do it here.
Of what to get rid of, that's a really tough call. I mean, it's between restructuring EDM and eliminating the safe harbor. I think I'd opt for restructuring EDM and assume we could get around the safe harbor by redefining what we mean by related products, but they're both problematic. But more generally, what would I change? I would switch from the draft vertical merger guidelines to my vertical merger guidelines. And you can have them royalty-free.
So the change I would make is to make effects the centerpiece not structure by moving Section 4, follow the 2010 horizontal merger guideline structure and make Section 4 Section 2. What I would keep EDM as Section 6 as part of the effects analysis, understanding that it doesn't always come up, but to what extent it does come up, it often is not a cost reduction, but is a price effect that belongs there.
Okay, so what would I add or change? I basically would add more framework and process, namely more forests, more trees. That I should mention, at least on the forest side, Steve, even your guidelines, your version of the guidelines, I think could use more. Okay, good. So I'll send you comments and we can post those. So our joint guidelines might address that. So that's in terms of add. In terms of keep, so I'm going to play a little bit of a word game. So what I would do is, instead of keep, what I would keep out is a presumption that vertical mergers are pro-competitive. I think the current draft does a good line. Some could say maybe it gets too close to the line, but I think it doesn't include that language, and I would keep that language out, and this ties again to our discussion of EDM.
What would I keep? I think the section on access to competitively sensitive information is clearly written and covers the right issues that can arise with vertical mergers, and that may be why we've barely discussed that topic on either this panel or the earlier panel. So I would keep that section as it is. What would I change? I would add more types of competitive harm that we anticipate occurring in vertical mergers. And a couple that come to mind particularly for me are questions about two-level entry, questions about potential entrants, and questions about mavericks. So I would add discussion of those in the section about foreclosure and raising rivals' costs, with, of course, examples.
Okay, so I'd like to thank our panel very much for a fascinating discussion.
And I'll extend the division's thanks to the FTC for joining us in this workshop today. And for those of you just thirsting at the end of this 4 hours for more on this, we do have a lot of other really thoughtful comments that came in and a lot of other participants scheduled for the workshop to be held at FTC next week. So coming soon to a building near you. Take care.